Shall I? I'm going to begin by introducing our speaker today, Enshen Li from City University of Hong Kong. And before that, a whole variety of other places in Australia and visiting positions there and in the United States. I think, Enshen, you are the first scholar we've had presenting in these sessions who has been not only a criminal defence lawyer, but also a prison officer. So that the diversity of those activities is very, very interesting. But in recent years, Enshen has written on a wide variety of subjects in lots of very good journals on criminal law and process and on aspects of terrorism studies and a whole bunch of different interesting things. But today he's talking to us about these particular features of sentencing in the People's Republic of China, and we're really looking forward to it. So thank you very much indeed.
Thank you, Richard. Thank you for the introduction. So thank you very much for this great opportunity to share my research here today. So the topic I'm presenting today is the Sui Generis case of China's sentencing pyramid. So in this presentation, I'm going to look at the sentencing system in China to understand how it has transformed and evolved in the context of the latest criminal justice reform in China. So in particular, I will look at the sentencing powers and sentencing practices to review how they have been redefined and restructured in the criminal process over the last 2 decades. So the research, has already indicated in many jurisdictions that the sentencing powers are no longer exclusively exercised by the judge. So a sentencing authority, that being said, a sentencing authority is being captured up by many other parties, including legislatures, sentencing commissions, probation and parole agencies. This is particularly the case in many Anglo-Saxon jurisdictions. So in this presentation, this study, I will look at China as a case study to understand how sentencing power has been reshaped in the criminal justice reform in China, in the country, where the social, legal, and the culture conditions are vastly different from those in many Western jurisdictions. So I think I would focus primarily on 4 research objectives in this study. So first, I would aim to tease out the new developments in the power dynamics of sentencing in China over the past 20 years. Also, I'm trying to understand the reallocation or redistribution of sentencing powers across criminal justice authorities in China, namely the police, prosecutors, and the judges, how they exercise their new sentencing powers on a daily basis, and to understand the inner workings of the way they exercise those powers. And also I'm trying to develop the new theory that can explain the new sentencing patterns and trends in China over the past 2 decades. I think the one particular aim of this study is to promote future empirical investigations into relevant issues that I'm going to raise in this study. It is simply because this research is largely theoretical on the basis of analysis of the government policies and the legal rules and the findings of the current literature. So it will be important to encourage and invite future empirical investigation to either challenge or verify theories that I raised in this study. So these are pretty much the research objectives or aims I'm trying to achieve in this study. Before we get to the discussion of the sentencing powers and practices in China in the past 20 years or so, I think it is imperative to first look at the criminal justice reform in China during the post-2000 period, just to give the contextual background for us to have a better understanding of the sentencing powers and how sentencing powers have transformed during that period. I think it's just impossible to highlight every important reform agendas in this presentation given the time. So I specifically selected these four criminal justice reform practices these are the most relevant reforms that we need to look at and to understand the new form of sentencing powers in China. So the first thing China did since 2000 is to shift the penal culture from strike hard to combining leniency with severity. So strike hard policy was used as a very popular approach to crime in 1980s and 1990s when China started to open its door and initiated the economic reform. So that was very popular during the time. It's simply because the consequence of the move towards modernization during the time was the significant rise in crime. So Chinese governments believed that the heavy punishment was the answer to restore social stability and order. Hence, they launched nationwide a number of strike hard campaigns to target the people who committed crime. And they imposed heavy punishments everywhere on people who committed a crime, regardless of the level and the nature of the offense they committed. So in other words, people who committed serious crimes will receive life imprisonment or death penalty with immediate execution. And that would also apply to the people who committed minor offenses. So there's no difference in terms of the application of heavy punishments in terms of the type and the nature of crime. And in the meantime, the trial process and the sentencing process was conducted in a fairly rapid manner. So it often took like a couple of hours for the judge to finalize the trial and the sentencing process to hand down the heavy punishments such as life imprisonment and sentence, and the people would be sent to be executed immediately. So that's what's actually happening during the strike hard campaigns. And that policy since 2000 was deemed ineffective on controlling and preventing crime. In particular, governments believe that the strike hard policy happened to be counterproductive to the country's effort to maintain social stability and order. I think that the particular evidence of that is that every time when a national strike hard campaign was over, the crime rate jumped quickly back to the same level, as before the campaign was started. So what happens in the beginning of the 2000s is that the Chinese government introduced a new policy called combining leniency with severity. So this new crime policy calls for a balanced approach to punishment and the crime. So it basically encouraged the use of harsh punishments only for the most serious crimes. So harsh punishment should be only reserved for the most serious crimes, whereas lenient sentence should be applied to the people who committed minor offenses. And the majority of the offenses in China since 2000 and actually minor offenses. So that's the balanced approach to punishment, which is in place in China since 2000s. But in the meantime, we have seen evidence of the police power being expanded, which is also part of the criminal justice reform during the same time. So we see that the police, they become more active on the streets to perform their duty of preserving social stability and to safeguarding the public. So they can be demonstrated and understood in two respects. First, so the police that are giving more powers to detain people who committed street-level offenses, and that power is called administrative detention power, and I will discuss it in a minute. So the police that are given more powers to administratively detain, incarcerate the people committed in the street-level offenses without the involvement of prosecution and court, which means that the police can single-handedly put the person in the detention center for committing administrative level or public order offenses on the street. So that's one thing. And the second aspect of the police power being expanded is on the arrest power given to the police over the past 10 years. So the arrest power is becoming wider and wider. It's simply due to the fact that a new legal condition is included in the criminal justice law, criminal law and criminal procedure law, to allow the police to detain, to arrest anyone who is deemed socially dangerous. Okay? So the social dangerousness has become the new legal condition or the new legal threshold for arrest, which unfortunately is left undefined in the criminal procedure law or any legislation on policing. So in other words, the police now have the power and authority to arrest anyone who deemed socially dangerous as they see fit. So there's no restraints and there's no supervision over the police using the arrest power, which means the police, they are at their discretion to decide who they want to arrest, in the context of the new criminal justice reform. And since 2016, so we have seen the rise of the plea leniency. So that program is relatively new. So plea leniency is designed to encourage defendants to plead guilty in exchange for lenient sentence. So in some respects, it shows similarities with the plea bargaining systems used in many common law countries, including the United States, United Kingdom, and Australia. But if we look at the practice, apparently they differ significantly in substance and in spirit. And I will touch on this in more detail. But I think the rise of the plea leniency apparently is driven by the concern of the efficiency in the Chinese criminal justice system. So what happens is that the criminal law in China has been increasingly expanded. There's a move towards the over-criminalization, which means the prosecutors in prosecution, they are facing increasingly more and more criminal cases every day, so they have to deal with on a regular basis. So their primary concern is just to get rid of these cases and clear their plates as quickly as possible. So that's why the Chinese government's introduced in the plea leniency, sort of they have the prosecution to deal with the case, to finalize the criminal cases as quickly as possible. And if you look at the past years, we have seen the advent of a new scheme called the tri-centennies taking place in China. So this is really something new, because the idea of introducing the tri-centennies is to reverse the pattern that in the previous trials, so the defendant's conviction and sentence is pretty much determined by the written evidence produced by the police outside the courts. Okay. So such evidence was barely challenged, verified or cross-examined. And the judge simply relied heavily upon some written evidence produced by the police to convict the defendant. So that has led to many wrongful conviction cases in China, and that generated the public outcry over the question over the integrity of the criminal justice system in China. So the purpose of introducing the tri-centennies apparently is to place the focus of the criminal justice system on the court proceedings, and allowing the judge to be the dominant player in determining the defendant's guilt and the sentence. Okay. There are so many adversarial elements included in the process of the tri-centennies. I'm not saying that the tri-centennies has been fully implemented in China, because the practice varies, but it has taken shape in some regions, and the adversarial tri and the fair tri has become the sort of the purpose and the aim that governments are trying to achieve, to ensure that the criminal justice process is fair. So against this backdrop, my argument in this presentation is that the sentencing powers have been redistributed across the 3 different law enforcement agencies in China's criminal justice system, according to the nature and the level of the crime they're dealing with. So that's why I'm calling the sentencing power as the sentencing pyramids taking place in the Chinese criminal justice system. So if you look at the bottom of the pyramids, we see that the police, they become the dominant player or the sentencer of the offenders who committed infractions. So infractions are the offenses deemed not serious enough to warrant the criminal prosecution. So they're the least level of the offense, equivalent to, for example, regulatory offenses or summary offenses in many Western countries. So for people who committed the infractions, then the police, they have the power to impose the civil penalties and they use administrative detention to finalize the cases, in a pretty rapid manner. But if we go up if we climb the ladder, go to the second level, the middle level of the pyramids, which involves the misdemeanors and the prosecutors. So we understand the prosecutor here becomes the sentencer of the defendants who committed the misdemeanors, pretty much through the use of the plea leniency program. Misdemeanors here, strictly speaking, misdemeanors is the legal term often used in the United States. There's no clear definition of the concept of the misdemeanor in the Chinese criminal law, but I'm just borrowing this idea, this legal term, to indicate the minor nature of the crime committed by people. So prosecutors, they mostly deal with the misdemeanors through plea leniency, and in that process, the prosecutors, they have the authority and the power to determine one sentence once the offender enters in a plea agreement with the prosecutors. I think it's pretty much what's happening in in many common law countries, jurisdiction, including the UK and the United States. So if you go to the top of the pyramids, we see that it involves the serious crimes and the courts and the judge being the final decision maker of the one's sentence. And it is often conducted through a trial sentence initiative. So if someone commits a serious crime, and very likely that would be the proper trial, during which the judge would assess the evidence to determine the relevance and admissibility and validity of the evidence, and to decide whether the person should be found guilty or not. And as a consequence, if someone is found guilty, is convicted, then the judge is going to hand down a sentencing decision. So that's pretty much the central arguments I'm making in this paper, in this presentation. So now let's look at these 3 levels individually. So if you look at the bottom of the pyramids, that involves infractions and police sanctions. And the infractions are as I mentioned before, the least serious offenses that the person can have committed in China. So they are not serious enough to warrant the criminal charge. So for police, what they normally do is they decide to take on these cases internally without getting the prosecution involved. And they often adopted 2 measures or 2 approaches to dealing with such cases. So the first one is a police mediation. So the police, they tend to play as the mediator, and the police would ask the defendants and the victim to sit down together and to talk about the crime, the harm of crime, responsibility and compensation, restitution, so on and so forth. So it is pretty much like a restorative justice program, and then the police is just playing a role as mediator, to encourage both parties to enter a reconciliation agreement, okay, as a way of finalizing a criminal case. So once the victim and the defender, they reached the agreement, then only civil penalties as opposed to criminal penalties would be imposed by the police single-handedly, okay, without the participation of the prosecution court. So the police, they do have the power to issue the civil penalties for the infractions committed by the offenders. And it is a common practice. So evidence, the research has indicated that it is common practice in cases involving, for example, pity injury, traffic-related offenses, property offenses, domestic offenses. And if the case is involving offenders being juvenile or college students, the police, they are more willing or more inclined to adopt mediation as a way of, finalizing a criminal case involving infractions. I think the main rationale behind it is that the police is trying to prevent the juveniles and the college students from facing collateral consequences brought by criminal conviction. So if the case goes to the prosecution and goes to the trial, it's very likely that the defendants will be found guilty or convicted. There will be the criminal records. And unfortunately in China at the moment that we don't have the system that can conceal the criminal records. That's something that the lawmakers being urging the government to consider, to take into account, as part of the next round of the criminal justice reform. But it's gonna take some time. So that's I think the first approach the police often adopt to dealing with infractions. Also, the second measure, the commonly used in the practice by the police is the application of administrative detention. So as I mentioned before, administrative detention is a custodial penalty that can be exclusively imposed by the police on people who committed street-level offenses. So there are a variety of administrative detention measures that can be used by the police, but the public order detention is one of the most common measures that we see in it every day, is increasingly visible in the public forum, used by the police to target the people who committed street-level offenses. So here so for example, public order detention, if we look at the if we look at administrative penalties law, then we see that a public order detention often carries 3 to 15 days of the and it really depends on the police as to how they assess the nature of your case to decide how many days will be appropriate, for incarceration. So here I use a battery offense as an example, and we see that in cases involving battery offense, the use of the public order detention, the number of the cases involving the use of public order detention has increased more than threefold since 2000 to 2022. Because then the battery offense is the offense which carries the minimum penalties of 3 days of public order detention. And the battery offense is just a tip of iceberg. And there are so many other similar offenses in which that the offenders would be sent to the public order detention, to be placed in the detention center for a couple of days as a punishment. So there's also research demonstrating that if we go back to the police mediation, that's sort of a strategy used by police to deal with the infractions. And we see that there's also research indicating that if the offender refused to enter a reconciliation agreement with the victim, very often that the police would impose the public order detention as a punishment, as opposed to civil penalties. So that's sort of like the pressure placed on the offenders to accept the responsibility and compensation deal with the victim, because if you don't do that, then very likely you will be sent to the public order detention, as a punishment. Then if we go to the next level of the pyramid, that would be the middle of the pyramid, which involves the misdemeanors and plea leniency. So in here, my argument is that the plea leniency has been used pretty much as the sentencing process for the people who committed minor offenses, namely misdemeanors. But I think it's important to first understand what the Chinese plea leniency entails, just for us to have a good understanding of how sentencing can be sort of manipulated and controlled by the prosecution single-handedly. So that program was officially introduced and formally established as the principle of criminal justice in 2016. So as of 2022, the application rate of leniency reached 90%, which means that in the vast majority of the criminal cases, leniency has been used as primary approach to dealing with offenders who committed misdemeanors. And it resonates with the fact that in China these days, over the past 20 years, we see that the minor offenses, misdemeanors, have taken up the almost more than 90% of the criminality in China. So that's why we use the plea leniency as a primary approach to dealing with minor offenses. But I think it's interesting to note that there's a big difference between plea leniency in China and the plea bargaining in most Western jurisdictions. I think the difference pretty much lies in the lack of the elements of negotiation. So in plea bargaining, more or less the defendant and their lawyers, they have the right to negotiate with the prosecutors in terms of the charge or sentence. So they often trying to seek a lesser charge in exchange for guilty plea. But in plea leniency, the defendants, they unfortunately do not have that right. So they don't have the right to negotiate a deal with the prosecutor. So what they are forced to do or have to do is to admit guilt willingly and to agree upon the alleged charge without negotiation. So there's no room for the defendant to negotiate a lesser charge, and they will have to accept the sentence recommended by the prosecution. Okay, so the way the procedure is that the prosecution would just present a plea agreement, a plea deal, with the charge and the sentence. You would have to accept it, without negotiation and without making any efforts to change the terms or change the content of plea agreement. So you would just have to sign it, despite the fact that the Chinese criminal law requires the presence of the lawyers during the plea leniency process. But much research has indicated that the presence of the lawyer plays very limited role, very limited, and being very ineffective in terms of protecting defendants' individual rights when facing the prosecution in the plea leniency process. So they would just have to agree upon the charge and accept the sentence. Having said that, many researchers, they have claimed that the prosecutors, they have become the de facto adjudicator in the plea leniency process. So now they are in charge of an investigation. So they can put in their hands in the process, the investigation, which is called early intervention. So early intervention, that practice is permitted by the criminal law, which means the prosecution may decide to get involved in the police investigation, leading the police to collect the evidence in order to satisfy the legal thresholds for criminal prosecution. So they can do that. Okay? So they can guide the police through the whole process of investigation. And this is particularly the case during the COVID-19 period. So the prosecution, very often that prosecution are actually asked by the police to join the stage of the investigation in order to collect and get evidence that can charge, citizens who breach the public health laws during COVID-19. And of course, the prosecution may decide what criminal charge to be laid against the person, and there's no negotiation over a new charge and or lesser charge from the end of defendant. And the prosecution basically can determine the conviction of the defendant. It's simply because when the defendant enters the plea agreement, then the agreements will be submitted to the court, and the judge would just have a speedy hearing to verify one thing, which is whether or not the defendant is willingly and voluntarily plead guilty. So that's the only thing the judge needs to confirm. In other words, in a speedy trial, in a speedy hearing, the judge would have no time to go through every details of the plea agreement, to have a comprehensive assessment of the evidence presented by the prosecution. So for the judge, and I think the efficiency is also one of the rationales behind it. So for the judge to get rid of these, criminal cases involving misdemeanors, and the judge would just simply tick all the, necessary boxes. And the most important one is that the defendant agrees to enter the plea agreements willingly and voluntarily. So in the meantime, the sentence recommended by the prosecution is barely questioned by the judge. So all the sentences recommended by the prosecution in China these days, according to the empirical studies, now almost all accepted by the judge without challenges, without any questions. In other words, the prosecutors are really the sentence of the defendants, of the offenders. I think there are two reasons behind it. The first one is, as I mentioned before, the judge, they just simply don't have time to go over the plea agreement. Okay, so if they see the sentence recommendation or the proposal made by the prosecution in terms of the sentencing options, then the judge would just simply accept it without questioning. So the other reason, I think, lies in the fact that the prosecution in China has long been established as the supervisory body in the criminal justice system. So in other words, the prosecution, they have the power to oversee the work of police, prosecutors themselves, and the courts. So the prosecutions, they can simply identify the error made by the police and courts in terms of the application of law, and appeal the case to the higher courts against the judicial decision or the decision made by the police, in the name of correcting legal errors made by other criminal justice agencies. So it is pretty common that when the prosecution recommended the sentence, the judge would just simply accept it without any difficulty, because they're trying to avoid in the future legal responsibility if prosecution decide to challenge that decision, the judicial decision, which is not in line with the prosecution's decision on the sentence, then that would be sort of responsibility incurred, and the handling judge is likely to be held accountable for that so-called error in law. So we have this Yu Jinping case, which is a pretty high-profile case that can indicate this sort of mentality shared by the judge in plea leniency process. So Yu Jinping is a defendant who was convicted of traffic-related offense, and the Beijing Mentogo District Procuratorates recommended imprisonment for 3 years. So that's the sentencing recommendation made by the prosecution, but the district court in Beijing rejected the sentencing recommendation and instead sentenced the defendant to a jail term of 2 years. So they refused to accept sentencing recommendation. Then afterwards, the Beijing Municipal People's Procuratorate appealed to the Higher Court on the basis that District Court sentencing decision was in error, and the Appellate Court ordered the sentencing imposed by the District Court be set aside, and the prosecutor's original sentencing recommendation was awarded. So this is not a singular case in China. So in almost every region of China, so if the judge decides to reject the sentencing recommendation made by the prosecution in the plea leniency process, the prosecution can always go to the higher courts to appeal against the decision made by the lower courts, and the successful rate is striking high. Then it comes to the top level of the pyramid, which involves the serious crimes and the trial sentence. So for someone committed a serious crime, then the trial sentence, the trial focus procedure would be the primary approach to dealing with people who committed serious crimes. So as I mentioned before, I think what the government is trying to do is to reverse the pattern that the previous trials relies heavily on the written evidence produced by the police, and such written evidence is just taken without any doubts on the challenges from the other sides, namely the defense of the defendant. So that has led to wrongful conviction. There's so many wrongful convictions being publicized, being reported now in China. It has generated public outcry, of the government, in particular the legitimacy of the government in terms of how the government has the ability to make sure that the trial, the criminal justice process, is fair. So according to one of the criminal justice lawyer in China, so these wrongful conviction cases are mainly due to insufficient professional qualities of investigators, extortion of confessions by torture, and the backwardness of facilities and techniques. I think the much of the evidence used to convict defendants is related to confessional evidence, confessional evidence, and the confessional evidence has never been challenged during the trial. So what they're trying to do is now they adopt the trial sanctions idea, which calls for the fair and adversarial trial, which involves the live witness, the testimony, cross-examination, and court debate, trying to encourage both parties, prosecution and defendant, to be confrontational, to discover the truth of the case. And pretty much they're trying to borrow the patterns and practice and widely used in Western adversarial systems to operate their trial process. Again, I'm not saying that the trial sentence has been fully implemented nationwide in China, because some regions, they have made the substantial effort to adopt the trial sentence, whereas some other regions, they just not really into it. But nevertheless, the power to punish and sentence the offenders remains intact with the judge. So the judge will become the final decision maker of one's. Sorry, I'm just running out of time. I'm just finishing the last slide. So I think the conclusion I'm trying to make here is that there's a sentencing pyramid that's taking place in China, and I'm not saying that it is happening in the full picture right now, but I think in the direction where the Chinese criminal justice system is heading, it's definitely taking shape and will become the norm of the sentencing practice in China. But unfortunately, the sentencing pyramid is not the system per se, just simply because at each level of sentencing pyramid is highly independent and loosely interconnected. So each level at each level that the law enforcement agency that clings to different programs, procedures, and principles. They do not actually share the common goal. They seek the different sentencing aims. And they have nothing to do with each other. So for example, if someone committing an offense and the person enters in the police sanctions, then it has nothing to do with plea leniency or trial sentence. So at each level, they are just have their independent power, and they are doing the things within their own purview. So it would have implications for future criminal justice reform, unfortunately. And I think it will be helpful to invite future empirical investigation into this topic. I think it's highly needed to test this hypothesis that I raised in this study. Okay, so that's the end of my presentation. Thank you very much.